My name is Marty Shenkman. I'm joined by my partner, Thomas Tietz, by Walter Primoff. Walter, tell everyone your firm name because I apologize, but I didn't have
Okay,
it
it's
written down.
it's Perelson Wiener Accountants and Advisors.
And you had a stint with the New York State Society of
Yes,
CPAs. Just tell
yes,
everybody what you.
I had been the deputy executive director of the AICPA at the time when of the New York State Society of CPAs, excuse me, at the time when the AICPA did its first standards of tax practice. I was on that committee. So I've been involved with this area for a long time and Circular 230 with it.
And Walter and I did some interesting stuff with the Corporate Transparency Act on the unauthorized practice of law. And last but not least is Bob Keebler. Give a little wave, Bob. Everybody knows Bob Keebler. And let's get started, Tom, and I'll introduce the program and then we'll have a quick word from some sponsors. Um, so before I turn it over to Teresa and Miriam for a quick word, the IRS very recently issued an alert talking about the use of AI, artificial intelligence, in practice. In tax practice, while our focus may be estate planners, I'm pretty confident that this will apply to the vast majority. I may be wrong, and we'll discuss it later. Walter may have a different view, or Bob, but I think it applies to the vast majority of not just estate planners and not just tax practitioners, but I kind of think that if you're a financial advisor and you upload a tax return into an AI program to generate planning ideas, you're ensnared by this as well. So we're going to talk a little more about it, but I just wanted to start off by saying I think this affects lots of people. And I think it's really important because it could set the stage for how liability may be determined. It affects almost everyone. And Walter and Bob, maybe even Tom will disagree with my read of it. But my read of this alert is that it's very worrisome and uses standards that could be really tough for anyone to meet. So get excited and stay tuned. First sponsor is Interactive Legal, Teresa. And if you want to make any comments about AI, feel free to.
Well, I will try not to take too long. I could probably talk about that for a while because we've all been sitting in on so many webinars and we've been presenting so many webinars ourselves on the topic with you know, various approaches and looking at it in different ways. Drafting documents, we get a big resounding no. We don't want to use it for drafting documents, but where can we use it? And so there's been a lot of focus, of course, on ABA Formal Opinion 512 for lawyers, but then this IRS alert also has caught everyone's attention, as you mentioned, Marty. And so we, of course, have a document generation system and we do a lot of education. And so we're looking at AI on how we can use tools in some ways, like summarizing documents. But we don't do a lot as far as tax reporting goes and what we provide as a service, but it's definitely a subject that we work with all of our subscribers on, and there's a lot of discussion about. So I'm very interested to hear your take on this IRS alert, especially since I think it does extend farther than just the people who are submitting the tax returns. And also
100%.
and the idea of putting a tax return into an AI just gave me, chills. Marty, don't do that. But I'm sure you'll talk about the whys and the caveats on that. So again, we're really glad to sponsor this program because AI is at the forefront, it seems, as far as what everybody's talking about. So glad to be here.
And our second sponsor is Peak Trust. And Miriam, is that actually you or an AI bot? I just wanted to clarify.
No, this is really me. Oh, thank you, Marty. My name is Miriam Hall, and I'm manage marketing for Peak Trust Company. We're honored to be able to sponsor today's presentation. We really appreciate all the educational content, Marty, that you put out. And of course, this is no exception. Peak Trust Company offers trust administration for sophisticated estate planners. We offer a full range of trustee services. We work with families and their trusted advisors, offering flexible and customized admin services for all types of trusts. So if you have any questions, of course, feel free to reach out to me or any member of the Peak team. And with that, I'll kick it back over to you, Marty.
So one thing at the outset, AI is changing so fast. It's like if you haven't gotten on the train, you got to get on the train because it's only going to get harder to get on the train as time goes by. And the reason it's so important to say and focus on how fast and rapidly AI keeps changing is anything we cover today and any examples we use today in a couple of months, it may be different. So just keep that thought in mind. The IRS Alert 2026-19 applies to tax practices using AI. And as I said earlier, I think that's pretty much everybody. Even if you don't think you're using AI, you're using AI because, and I'll let Bob and Walter comment, because almost every service or software any of us use may have an AI component to it. So it's not just going into Claude or Copilot or whichever AI you use and asking a question. It's embedded in almost everything. The alert that we're going to talk about, I think is incredibly important, to me very worrisome. I'm hoping Walter or Bob will convince me I'm wrong, but I'm not sure if they will. It addresses due diligence, competence, fees, written advice, firm procedures, confidentiality, documentation. We're going to talk about all that. But like I said earlier, it applies to, I think, almost everybody. And from what I just kind of rattled off from the second bullet point on the slide, it covers so many aspects of planning. And I think one of the key questions, and I'm hoping that Bob or Walter have some insight on this. One of the key questions is, does the alert really just restate existing duties like from Circular 230 and certain code sections we'll talk about, or is it creating a higher, more demanding standard? My interpretation is the latter. Why don't we start with Walter? Do you have any, you want, at this stage, some introductory comments or thoughts on?
I do have some thoughts, and the main thought is the scope of Circular 230. There was actually a court case on this where Circular 230 in the previous version had some aspects to it that affected tax return advisors or preparers who were not attorneys, were not CPAs, were not EAs, and there's one kind of actuary that gets involved. If you are not in that group, you're not affected by Circular 230 itself. You're affected by other things. There is a whole panoply of regulatory and self-regulatory aspects to this that probably do draw in almost everybody, but not Circular 230 itself.
Let me ask you a question, Walter. If I'm a financial advisor and I got one of these newfangled AI programs that does all sorts of nifty stuff, and I upload a tax return into the AI cloud and get an analysis and tell the client some tax planning advice, am I not caught up in any of this?
You're not caught up in Circular 230. What you are caught up in is whatever regulatory agency you're regulated by that was mentioned in the Gramm-Leach-Bliley Act in 1999. The cybersecurity aspects, even for CPAs, are not actually in Circular 230. I never really understood why they did this, but when it comes to the written security plan that everybody needs, and when you get your PTIN, you see that's one of the questions. Have you read publication 4557, which is an IRS publication, but the real regulatory clout there is the Federal Trade Commission, and it's their safeguards rule, and CPAs are brought into that. I believe lawyers may be brought into that as well for the purposes of security over taxpayer data. So this is a much broader issue than just Circular 230.
Bob, any thoughts, comments?
So I think that's exactly right. And what we have to be mindful of, basically here is other people who aren't CPAs or lawyers are going to be using this to give tax advice. And then they're going to be asking us to review their advice. And there's a very high standard of due diligence required. And, we're using a lot of AI to get things started. And I think that's where, in the hands of somebody like Walter or you, Marty, who knows the law, has a good sense of things, using AI to jumpstart a project is absolutely brilliant. Where things go wrong is when somebody who maybe is primarily doing audit uses AI to solve a very complex tax problem, and they cannot identify the hallucinations, when things hallucinate. So, those are my initial thoughts. I'll come back to, I do agree with Walter, though, that this probably doesn't affect people who are not CPAs or lawyers. So the financial planners the IRS does not have the ability to discipline a financial advisor no matter how out of control they are.
And one of the things is their own regulators also have safeguards rules. So there is a fair amount. If you're a registered representative with a broker dealer, you're regulated by the SEC, and you have a fair amount of cybersecurity confidentiality in those rules, just as the CPAs have, who are involved in return preparation, have with the Federal Trade Commission rules. So this is not like you can just. There's a wild west out there where people who are regulated can do anything. Now, people who aren't regulated at all, they still come under Section 7216, involving what you need to be able to disclose tax return information. So there's a lot out there. I do believe there are some aspects to this IRS notice on Circular 230 that I very much disagree with, and I'm sure we'll get into some of those details. But as to the breadth of the impact of Circular 230 itself, I think is broad enough. It affects lawyers, it affects CPAs, and it affects EAs, and it affects a certain group of enrolled actuaries. But beyond that, the IRS does not have disciplinary authority.
Let me just make a quick comment and we'll move on. I don't want to belabor it. If I'm practicing as a financial planner and I take a tax return that Walter or Bob prepared and filed, and I input it into my AI software and I start giving advice on income tax or estate tax planning to the client based on an AI analysis of that. If I'm a financial advisor and I start offering to my clients to have tax returns prepared, even if I outsource it, but it's coming out of my shop, I would not want to ignore the standards the IRS promulgated, whether they technically apply to me or not. If I'm that deep into tax compliance, I'd want to be very aware of what this is. Let's move on because we have lots to cover. Tom, why don't we go on to the
Sure.
next
Can I make
slide?
just one quick point
Sure.
before we move on, Marty? And I want to do this as more of just an overarching viewpoint, because we're about to get deep into the weeds of the alert, Circular 230, and other points that we're considering. And that's going to put a bit of a damper on AI because of the points that are being raised. But remember that AI has a great amount of possibility of use when it comes to tax practice. One of the greatest strengths that AI has is synthesizing large amounts of data. And what are tax returns and all the attachments to it other than great amount of data? So how you're using it and what way you're using it, safely using it, it's important to be aware of all this, but don't avoid the use of AI because of the information that's out there.
So as we go on, let me make a general comment. I've spent a tremendous amount of time over the last decade reading a lot of the cases, maybe most of the cases, on malpractice complaints against estate planners. And one of the things that I've tried to do in our practice for a very long time, based on my reading and analysis of those cases, is be very careful about the wording that I use. We try to never use words like best or optimal, maximum tax savings, because I don't know how you know that you have an optimal tax plan or best tax plan because the law changes so often. One of the things that makes me react uncomfortably to this alert is the terminology that's used. And I just want to make this as a quick introductory comment. So they make comments in absolute terms like that you have to thoroughly review AI created documents. I agree you can review AI documents, but what is review? You have to have diligent that differ from human oversight or reasonable oversight. The terminology used, to me, that's something that I want everyone to pay attention to, because you're going to find as you go through this it to be problematic. Tom, do you want to talk a little bit quickly about the roadmap and just some of the language?
Sure. So this is just largely a quick covering of what we're going to be talking about here. I think one of the concerns and what Marty's talking about, if you look at the language that's talked about here, due diligence, written advice, competence, supervision, confidentiality, these are words that we've seen in previous kinds of ethics opinions, whether it's from lawyers with the ABA that have provided it. There have been other discussions but in various aspects, whether it's states giving it out, the ABA itself, rules of professional conduct about technology before AI, after AI. Those are languages and points that have been raised in the past. But if you look where the alert may go further, we have operational mechanics, robust safeguards. What does robust mean in that situation? Billing language. We're going to have a section about billing here. Our concern is the terminology that's used by the IRS in this alert. Does it potentially create a higher standard than what we've had in the past? And I will kind of give us a quick idea of what's been used in the past, and it's a magic word: reasonable. Many of the ethics opinions have discussed what are reasonable efforts to protect confidential client information. And that standard has been used because what is considered reasonable changes over time. I'll use passwords as an example. If you go back 10, 15 years, just having a password was considered a reasonable amount of effort. Then we had password managers and long strings of 15-digit passwords that had undercase, uppercase, numbers, what have you. Then multi-factor authentication came into effect, and you used your phone for that. Now we're bringing in applications on the cell phone rather than through SMS on your text message for those numbers. So the metric for what is considered reasonable changes over time. But contrast that to some of the language we're going to be talking about that the IRS used in this alert today.
Let's go on, Tom. One of the things that we're going to talk about is, because it's of concern to us as practicing attorneys, is the differences, and Tom's given you some indication of the language used in all the ABA guidance on technology and AI, which is extensive, versus what's in the alert. Walter, Bob, any comments on the alerts language and criteria versus accounting standards?
I don't have the one thing, the language bothers me of what the IRS put out has to do with the fees. I think they're way off. I think they're. No, I really think they're way off topic.
Oh, I agree.
They're
I agree.
just. I don't. I mean, the fact that you use AI doesn't necessarily mean that it takes less time. And sometimes I've used AI where I've gotten ideas from AI, but the ideas I've gotten to maybe take more time. And
Right.
sometimes I've gotten totally wrong answers from AI that I had to fix. So the idea that just the use of AI is always a big time saver, I don't think is correct.
we're going to come to that, and we're going to dig into that because that's one of the very worrisome points. Tom, let's go on.
Marty, on fees,
We're going to come back to that, Bob. We got a whole discussion on that. So let's hold on. I had a quote 2001: A Space Odyssey. Tom, I'll let you comment on it. I mean, how can you do a program on AI not mention 2001: Space Odyssey?
It's just a perfect example of the fact that art kind of follows the way that things are going. I mean, just look at, and I'll bring us to Star Trek because I love Star Trek too. They had communicators in the 1960s that were a herald to the cell phones that we have today. So the AI points that were in A Space Odyssey are showing exactly the kind of issues that we're having today. HAL went off the rails. AI can go off the rails too. You got to be cognizant of it.
For the 3 people that don't know who HAL is, tell everyone who HAL is.
HAL was the AI computer that was on the spaceship, and HAL, I guess you could say, kind of went the way of the Terminator for those that are more that know the Terminator series.
Okay. Walter, do you want to comment on a high level about professional judgment, what the alert requires
No,
for when we
I
use
think
AI?
I think high level professional judgment is key here. And one of the things that I think the guys like me, you, and Bob have are all of these years of experience to have developed a judgment and know and really have a very quick feel of when AI is going off the rails. Younger people who don't have all that experience, I think they have to be much more careful, and I think they have to be trained a lot better. Because if they over depend on this, they can get themselves and a firm in real trouble. So it's like just like some of the attorneys who've had these briefs, I've had AI at times tell me there's a tax court case that never existed.
I had that happen a few months ago when I couldn't
You know,
remember the citation. I think it's the Rowland case on portability. And I asked AI for it, and it came up with a completely fictitious citation.
yeah. So it's this is something you have to have really good judgment about what the code is about, how the tax law works, what makes sense and what doesn't make sense when you look at the body of an AI answer. I think professional judgment is at the top of the list here.
Anyone else have comments on this slide? If not, I'll give one comment before we go on.
I always like to think of back when we were in school, even though you had a calculator, you still had to learn your multiplication tables and long division. Think of it in the same way with AI. If you don't have that background, you're not going to be able to sniff out when there's a problem with what you've got.
I agree with a concept in the alert, and it builds on what Walter just said, or follows from what Walter just said, of professional judgment. But let me give you an example that goes to the 3rd bullet point. Practitioners must review AI output before client delivery. Really? When I read the alert, it says, the way I read it, that I can't just take AI output without having a professional verify all of it. Let me give you a couple of examples that have happened. We had a situation where, and this happens all the time, voluminous data on the client matter, voluminous data, operating agreements, tax returns, memorandum, on and on and on. I wanted to confirm the percentage membership interest of an LLC in regards to certain planning. So I asked AI to look in the Jane Smith file and find every instance it could where the membership interest percentage was stated, tell me which document it found it in and what percentage it had. And AI picked up a couple of inconsistencies. The way I read the alert, I have to have somebody on staff manually go back and check all of that before relying on it. Here's the problem. For a professional, even a paraprofessional, to go review thousands of pages of documents, hundreds of pages of documents even, be 5 hours, 10 hours, and that's not guaranteed. It's so tedious and so much minutia. Will you catch everything? If I said to the client, I'd like to confirm there's been consistency in reporting for a gift, the appropriate percentage interest. I can have AI do it. It'll take us maybe 20 minutes to coax an answer out of AI, maybe a half an hour to review it. If I have to assign somebody to go back and go through all those files manually, it could be 10 or 20 hours. The client very well may say, forget about it. I'm not spending that kind of money. Just use the number and call it a day. But the AI at least could ferret out some of the issues. But what the alert seems to say is we have to go back and have a human being check the AI. I think that, in my professional judgment, would be unfair to the client, unfair to the practitioner. The client wouldn't take any steps to corroborate the consistency of determining the membership interest because the cost is too high. But if I can do it for 5 to 10% of the cost with AI, knowing it may not be perfect, for example, what if there's a photocopy of a photocopy that was then made into a PDF? It may be too fuzzy for the AI to pick up on it, but a human being may be able to discern what that membership interest is. So I think there's real concerns where they mandate things in the alert to be done that may be contrary to what our professional judgment is. And that's problematic. Any comments, anybody?
Yeah, I think there's, in the practical world, I think there's a materiality factor here. If the AI makes a major mistake that really affects the numbers, that somebody misses, or screws up a court filing that somebody misses, I think a professional could be held as being negligent. If it's something very minor and immaterial, I'm a lot less concerned about that. Once you get into what you're talking about, the going through thousands of pages, it's what's being looked for, and is there a reasonable percent that's okay? I mean, it's just like doing probabilities. When you're doing statistical sampling, you never get 100%. What is a reasonable? You come back to that word reasonable again. What's a reasonably acceptable error rate in a situation like that? While you're aware that if it's anything major, you really have to fix it or find it.
Tom, let's go on.
Sure. Before we go on, I just want to comment on what Walter just said, because I think Walter nailed the intent behind it. But one of the concerns, and Walter, you could tell me what your thoughts are here, is I don't feel that the alert actually spelled out the benefit versus risk factors that Walter just talked about. That level of reasonable consideration is what previous ethics opinions, like the ABA opinions, have said in the past. But what the IRS alert is saying here is that practitioners must review the AI output without putting any sort of definition on what review is, or putting any sort of caveat on that of what is the AI output that you're reviewing, the risk, what is coming out of it. Is it technical tax considerations, which require a higher level of review like Walter was talking about? Or is it something like Marty was talking about, where it's just confirmation of percentages across many different documents? So think of that as we're talking about this here.
Care. It's a pretty broad standard. And I think everybody needs to have some understanding if you're doing anything with tax returns. And Walter gave a much more technical answer than me. I gave more of a litigation worry concern. Even if I'm a financial advisor, if this is what the IRS is mandating and I'm either getting tax returns under my auspices sent out or using them and giving tax advice, I'd want to know what the IRS has to say. Let's go on. Everyone should care. Tom, why don't you introduce some of the core standards real quick? And Walter, you can feel free to comment too, because this is Circular 230 stuff.
Sure. So I'll just go through the different aspects that the alert was talking about with Circular 230 here. I'm not going to use the actual section numbers since they're right here on your screen. But it talked about due diligence, which we were just talking about, verifying the output from the AI. What are you getting before you submit it to clients or to the IRS? We haven't really talked about submitting to the IRS as well. So the level of review depends upon what it's being used for. Is this internal use, initial? Maybe less due diligence is required in that situation. Fees, we're going to talk about that in a lot more detail. We've already had some concerns. Walter raised it, Marty raised it. Competence, that goes back both to due diligence as well, but how are you using the AI? Do you understand the concept of what the AI is creating information on enough that you can see if there's something wrong with what the AI is creating? Firm procedures. It's not just the practitioners themselves that are using these AI programs. It's paraprofessionals, it's admin staff. How are you getting these AI programs? They're from third parties. What are the agreements with those third parties? That's going to affect this as well. Written advice. It's talking about what are you relying on in the advice that's created by the AI here. Conduct. It's once again, that's 7216 that we were talking about earlier. How are you disclosing information? Are you protecting confidential client information there? And tax return information. This is just, it's kind of bringing everything together. This isn't just about Circular 230. There's other points, like Walter mentioned earlier, that we have to deal with here. Walter, any thoughts on this?
Well, yeah, I think uh, this is really a matter, again, I think this comes back to professional judgment. And Marty, I can't guarantee that you're not right, but I think at the end of the day, when the IRS looks at this or has anybody looking at this, if the CPA or attorney can show that what they did was reasonable and they took reasonable steps to for due diligence on here, and if there was somebody accidentally missed something immaterial, I don't think it's going to be different than what people do without AI.
Bob, any thoughts or comments? And maybe both of you could comment about firm procedures. What are you seeing firms do? Are firms starting to develop AI procedures? Is that still too new?
I certainly haven't seen that yet. And where we're using AI is to jumpstart projects, not to finish them. And I can tell you around here, every citation will be checked. If it cites a revenue ruling, that revenue ruling will be read to make sure it's on point. And it's got to be a very high standard. The moral of the story is, this is where I agree with the IRS, we can't get lazy. We can't just type it into AI, Marty, and send it out to a client. But we also have to we just still have to try to be efficient. And AI should help us with that efficiency.
Yeah. I think there's a difference between what Bob just said, checking all the citations and the revenue rulings and the cases and the code sections, and checking every last item in a 1,000-page submission that you put in AI to see if there was any little tiny thing missed. You have as much chance of missing it doing it manually as, once you get to something that long, nobody's going to likely be 100% correct.
So let me add a couple of quick comments. I hope Walter's right, and I hope I'm wrong. But the lawyer in me says I have to read the language and the terminology used in the alert. The language and the terminology expressly does not use a reasonableness or professional judgment standard for many of the statements and many of the standards it creates. That is deeply worrisome to me. I hope Walter's right that if you ever get down to brass tacks, the IRS will apply a reasonableness standard, but they could have and should have said that, and they should revise this to say that, and they can follow the same language and lots of ABA guidance, because especially for a solo or small firm in any discipline, whether it's financial, accounting, law, it's much harder to address all these points. Let me give you another example. I don't know that everything can or needs to be reviewed in my professional judgment. That's not what I read the alert as saying. Example, I had a client that has a vacation home in a different state, and there's some state level estate tax issues on that home. And he told me what he wanted to do, and he really didn't want me to spend much time on it. But my gut was that he's going down the wrong path and misunderstanding the law. So I'm not an expert in state X estate tax, but I posed a couple of questions and hypotheticals to AI because, as Walter said, with 40 years of experience, I kind of felt I knew how to pose the questions. I got back a bunch of answers. And what I did is I said to the client, you did not authorize me to spend a great deal of time on it. Here are some preliminary AI thoughts in my comments that I think warrant further review. So this wasn't giving final advice, here's what you can or should do. This was, here are issues that I raised with a preliminary AI search to find. But when I read the language in the alert, I can't send out preliminary guidance to a client suggesting more issues to follow up because I have to thoroughly review it. If I had to thoroughly review and research and test every reference or thought that the AI gave me on this particular topic, then I'd already be doing the work the client didn't want to authorize me to do. Does that make any sense to Bob, Walter, you guys?
Well, I do think you can't send a partial answer to a client.
I don't agree.
But I think preliminary answers. Yeah, I mean I've done that, and preliminarily, this is what it looks like, but more work has to be done to get the final result.
I think that's necessary to even identify
Yeah.
some of the possible issues.
So,
But by the way, just in fairness to what I did, I put a big, and I did it in bold. I don't know that you have to, but I disclosed to the client this is preliminary AI research done just to help identify some thoughts that we think you should pursue. It has not been confirmed and should not be relied on. Any other thoughts, anyone?
I don't think our firm would let us quite do that, but it's you have to know your client. For the right client,
See,
that might be the right thing to do.
This particular client, and I don't think this is uncommon, would not have authorized the cost for me to do proper research. I wanted to alert the client to issues that should be thought about. And I made it very clear that they can't rely on what we did. And I actually didn't even make it part of my memo, it was an exhibit. So it was very clearly delineated. But you see, to me, that's the power of what AI can do to help get better results for clients. Client, you didn't think this was an issue. It sounds like you may be wrong and it should be pursued. Here's a little bit of reading if you want to get some thoughts on it. You can't rely on this, but I think it deserves more. Bob, what do you see as a problem with what I did?
I'm not so sure there's a problem as long as you caveat it. A lot of the work I do is with family offices where they already have lawyers and CPAs in-house. And many times I'll talk to them and they'll just be looking for ideas. And in the past, I might have just sent them a bullet point, check the following and then let's talk. And because they have so much talent in-house, they don't want me doing detailed research. They'd sooner do the detailed research and then come to me for analysis and wisdom, if you will.
See, but I think that's where AI can really shine for clients. I think it's important to make it very clear what level of work has been done. Why is that different than audit standards, right? Is it an audit? Is it just a compilation, a review, if that's still the right terminology? There's different levels of work. I think as long as it's clear what you're doing and how it can be used, I think you should be okay. But my worry is that level of professional judgment, because I wouldn't do that in every case. I probably wouldn't do it in a majority of cases. But for this particular situation that I gave you, I think it was helpful to the client and very cost effective. and the client can decide what they want to do with it. But the alert doesn't seem to give that latitude of professional judgment, and that's what my worry is. Tom, let's go on. Walter, do you want to comment on any of this?
Well, it's this I think comes back to the professional judgment. Preliminary AI research, I think, is fine for the right client if the client is the right person who can read it and understand it. I mean, sometimes we have clients who really don't want to discuss taxes. They don't want to get into the weeds. They don't understand the weeds. And if you send them something preliminarily that's wrong, that they get the wrong idea about, I think you could have a problem. If you have a sophisticated client who is aware of all these things, and the AI gives them some new ideas, I think that's fine, as long as it is is marked as what it is and not a final result. I don't really have a problem with it. Again, it's whether it's the right client.
The last comment that Walter made, I just want to emphasize it's the same comment I made. And the alert talks about this, and I think it's really important. When you give AI results to a client, you should indicate to what degree you did what. And if it's not a thorough review, if you haven't checked and read every citation, as Bob talked about, you better disclose that and say why. Tom, let's go on. Walter, do you want to comment on these Circular 230 items? You want me to cover it?
No, you can cover this.
Blind reliance on AI may be unreasonable, especially where logic or sources are opaque. I want to repeat what Walter said because I think this is really key. But again, I'm worried that the alert doesn't embody this. When you have somebody with decades of experience, they can kind of sense, even if it's a new area for them, does that make sense? Does it not make sense? Is the AI just, off base? I think it's important to test logically what you're doing. And I think that's also why a practitioner with lots of experience and knowledge is going to make a better inquiry than what a client or layperson without that knowledge is going to do. And that's also what worries me, where practitioners are getting way beyond their skis because they have an AI product that they can ask questions to, but they don't have the judgment because they don't have expertise in the area. That's really important. So again, I think the last item is what Walter talked about earlier. You got to clearly communicate to the client what it means and what you've done, whether it's final advice or just thoughts to consider. Very big difference.
Marty, you just said the most important thing we've heard so far is that over your skis. For example, if I, as a CPA, am looking at a very technical practice and procedure issue, I shouldn't use AI to allow me not to refer this to a lawyer who is subspecialized in IRS practice and procedure. And that's what I fear. And I think we're going to start to see that. We're definitely seeing that in the world of the financial advisors with no tax training at all, reaching into tax, and a lot of that is being done using AI. It's just not healthy, and it's not safe. And even for highly skilled CPAs and lawyers, we have to resist the temptation to allow AI to empower us to practice beyond where we're really good. And everybody's life will be much less stressful if we continue to practice in a way where when things get difficult or the numbers are large, we get help from somebody who spends more time in that space. And that's the biggest fear I have, is that AI is going to let us stretch too far. And that doesn't just apply to accounting and law in the world of tax. That could apply to any profession. It just gives you a false sense of confidence, Because I see financial advisors who aren't lawyers or CPAs sending me stuff off AI on tax issues, and it's really not, it's not a healthy practice.
I think we're going to see a lot of litigation as
Bob,
people get out over their skis.
Yeah, Bob, I totally agree with you on this. I mean, it's and you know, I haven't really seen much of it yet, but most of the financial advisors I deal with are in firms that have very strict rules about what their people can do with taxation. And they don't prepare returns, and they don't get into these real difficult areas. That's where they call people like Bob Keebler, or call me, or call Marty if it's a really complex estate issue. Some of them, some of the firms actually have people with decades of tax practice, and that's a little different, giving the problem to a person like that. But if a financial advisor is just looking at AI without understanding the the overall tax law approach, and the way things work, and not understanding when they are getting out over their skis, I think there's a lot of danger there if the clients listen to them.
I think what you guys are talking about is really what kind of motivated the IRS to put out the alert. They're probably seeing some really incorrect, if not ridiculous stuff being reported, and knowing and recognizing that it comes from AI. And it's not financial advisors. It could be anyone that's an accountant or an attorney that's just getting beyond their skis. If you're a general practice attorney that's done some wills, I think you want to be very careful getting into some GST allocation questions. It's really complicated. And I think that's where the alert was going. And I agree with the IRS trying to caution practitioners that you got to be prudent, you got to be responsible, and you got to know what you're doing. The concern I have is that the language used in the alert, as I've said many times, becomes nettlesome or worse for practitioners that do know what they're doing, but it seems to almost restrict what they can do. Tom, let's move on. We got to move a little faster, okay?
Okay.
You got to be competent. But Tom, how do they define this differently in terms of understanding technology versus the ABA?
So in the ABA decisions, reasonable efforts is the terminology that's used in all the different opinions and statements and comments to model rules of procedure that we have. However, in the IRS alert, they talk about understanding the AI system's operational mechanics, its limitations, its risks. Does that create a higher standard of needing to understand how the AI works under the hood? Kind of like how with cars, you know how to operate them, but you need a mechanic to be able to actually fix them if there's a problem. Are they creating for professionals a need to understand how large language models work, how their vector works with looking at the algorithms to pull the information together? There's some concerns that the IRS did not add color or guardrails over the understanding of what they're talking about professionals need to be able to understand AI.
So let's do a test. I'm going to put Walter and Bob on the spot. Okay, guys. All right, between the two of you, you probably have a resume that's 200 pages long, right? Do you guys understand at all the operational mechanics behind AI? Is that even plausible? Because if you guys can't understand it, who can?
First of all, I don't think CPAs or lawyers are charged with becoming IT professionals. You know, I mean, especially the people who work in AI, they are incredibly specialized. And some of them are brilliant beyond belief. I don't think anybody could, I don't care what the IRS writes, I don't think anybody could expect even the best CPAs and attorneys to be able to understand what AI is doing at that level. Having a general understanding about what a large language model is, and how it can be, and the fact that it can be in the wrong hands, it can give very biased answers. And that becomes a due diligence issue with whose AI you're using, and asking the right questions to get answers that satisfy you. And I think that's really the most that most CPAs and attorneys and tax practitioners can do. To ask the next level, in some aspects, you need a master's degree in mathematics, or beyond. So and engineering and computer science. So I don't see that as being a reasonable requirement. And if that was the requirement, there'd be 10 people in the world that could probably fulfill it.
So I agree
Marty, I think
100%, but that's not what the alert says, and that's what's
Yeah,
worrisome to me.
yeah, 2 or 3 hours of training is probably what's needed to take to heart that AI can hallucinate and that you can't trust it any more than you trust a senior in college who was your intern, who you said, find me everything you can on this.
I think that's a very logical litmus test. Treat AI like you would a junior professional, and nobody would let a junior professional write a complex memo on any tax topic and send it out the door. So I think that's the right standard. I just would wish that the IRS would go back and revisit some of its language, because it worries me that it's setting standards that are not achievable or attainable by, I'll use Walter's example if I remember the number, more other than maybe 10 people in the profession. Tom, let's go on. We got to move faster, please. Okay, Walter, you were gunning to talk about fees. The floor is yours.
Well,
And
I
Bob, you
think,
should comment as well.
yeah, I think fees have to be fair, reasonable, and disclosed about what it is. The fact that you're using AI, if you're not in a 7216 situation where you actually uploaded client information into AI, I don't know that you have to tell a client that you used AI any more that you have to tell them that you used tax management portfolios. I think all of this is a tool, and you have to come up with the right answer. And you're not going to give an AI answer at the end. You're either going to have revenue rulings, you're going to have real rulings, you're going to have real code, real regulations, real private letter rulings behind what it is you're giving a complex answer to a client about. And how you found those, I don't think is really relevant in billing.
Any thoughts on that?
Well, my biggest thought is, I think from a business perspective, everything we touch has risk. And if you use AI to cover more ground in your 8-hour day, you're taking on more risk. Okay, so you have to be conscious of that, first of all. And secondly, if a firm invests $25,000 per person to use AI to do tax returns, a firm has to get a return on that $25,000 per person. It wouldn't be fair to the firm not to get that return. So the market will decide what's fair pricing. The real issue that we have is probably back at the section we have before, but I'm just going to say it. The real issue is you have people who have passed their EA test, and many of these people, from the work I'm seeing on my private letter rulings where we're cleaning up things, are already reaching beyond their expertise. And I think this is just going to further empower them. So, and coming back to the fees on research, you're going to have to be disclosing things, and maybe some of these things we just ask for fixed fees on, Marty, instead of doing them hourly. Because, I mean, what happens, Marty, if I call you while we're talking, you type it into AI, all of a sudden you're back to something you already knew in the back of your mind, and you confirm what I should do in 2 minutes. How can you possibly send me a bill for 2 minutes? I mean, that's something we have to figure this out.
I think there's standards for this. So for example, historically, before AI, before the internet, if I did a research project 5 years ago on the Smith family on whether a real estate business qualified for 6166, and then the Jones family comes in, you know the first thing we're going to do is we're going to send somebody, at that time it would have been to an offsite storage, find the Smith file, take the Smith memo, revise it for the Jones family, and update the research. Would you bill Jones merely the incremental hours spent, or will you bill Jones something for the value of what you've done? Now, whether, the ethics rules, I believe, permit you to bill something for the value of what the client's getting.
The other thing is that the rule in Circular 230 itself is unconscionable fees. And I don't see, I mean, I looked at this release and I think they went way beyond what anybody or judge or anybody else would consider an unconscionable fee. And I agree, I mean, the wording is problematic, but I think the actual enforcement, the IRS is not going to be able to do that.
Walter, I agree with you. Billing something for the value of what you've invested is perfectly reasonable, and it's essential if firms are going to survive financially, and it's fair to the client.
And it's
But
not
they did go,
unconscionable.
it's not unconscionable, but the standard that they used is assuming AI is going to be only cost savings. And I'm going to quote you in a second because I agree with you. AI is always providing cost savings. You got to pass that cost savings on to the client. That's wrong, because what you said a little earlier, I agree with. A lot of times when I do AI research, I may find things and thoughts and materials that I couldn't have found manually, but it often takes as much or more time. I think the product, the end result may be better, but I may not be spending any less time. And you need to bill for that. It's not passing on a cost savings. It's all the standards that we've all adhered to for all of our careers of billing fairly and honestly and openly for clients.
I think the only way it's almost contradictory. I think the only way that that could be a correct thing is if you didn't verify everything. So the alert is saying that that you have to verify. Once you have to do that, and you should have to do that, that's not necessarily a time saver.
Let me give another example. Tom, I'm going to let you do this. Explain to people what a prompt is, because they know, but just say it quickly. But explain what we've done where we have some prompts that are 4 pages long, and we've spent untold hours developing and perfecting them to be able to do certain tasks. Because then we can talk, Walter, about how you have to value bill or bill more because of the huge investment. Tom?
So a prompt is a set of instructions that you're giving to the AI. It's just like if you had a paraprofessional or a lower level associate, what are you telling them to do on that particular project? So there are 2 common ways that people interact with AI right now. It's an AI program that you provide prompts to, where you're creating the set of instructions and getting the result from the AI. The other is when you have a program like a tax program that has AI built into it, where you are getting specific responses based upon what the AI program has done for prompts for its AI. So when you're crafting the prompts yourselves, you're basically kind of becoming the programmer of that particular question. So as time has gone on, as we've been using AI for certain actions, we will get results from the AI based upon what our prompt says. And we will then change our prompt. We will then narrow it down, make it more concise based upon issues that we identified from the net result from the AI. And we will even ask the AI at times, critique my prompt. Tell me if there's something that I can be writing in here that makes you get a better result based upon what I'm doing. That takes time. That takes preparation. It's very similar to how we consider forms that we have created as assets of the firm. In the future, proprietary prompts that each firm has may be considered its own valuable asset. And that goes back to what Bob was saying about you might have to spend $25,000 per professional in the firm to really get AI up and running. How are you going to recoup the investment that you've put into using the AI?
I'll give you a specific example. So when we draft documents, we do something that I think is very different than most or any other firms. We do them on a web meeting using document generation software, and we discuss almost every item we tick off, because there's thoughts. Should we do option A, option B, or option C? Traditionally, law firms would give a document to a client. Maybe they have a covering memo, but the client would only see the option B that was selected, not that they could have chosen A or C. If it's relevant for the client, we may mention, hey, we believe B makes sense and we've selected it in this draft, but option A, which is such and such, and option C, which is such and such, may also be of value to you. We record it, have AI take the transcript and write a memo. The prompt to turn that drafting detail into a memo is now 4 pages long and has taken untold hours and untold revisiting it and revising it and enhancing it to get it to the point where we can now give a client a roadmap that may go through 30 or 40 or more provisions in a will and revocable trust. And it takes us an hour and a half to review it because we've refined the prompt so significantly. The investment in creating that prompt is just like Tom said, it's in the old days when people didn't have document generation. If you had a good insurance trust form, you could spend untold hours perfecting it. And that would be part of the value of what you're giving to a client when you charge them for insurance. I don't think AI is any different, but I do think that the alert missed that point. Let's go on to the next slide, Tom. Any comments, anyone, on procedures, training, securing data, what firms may want to create in terms of AI policies?
I think all of these are required. This goes back to the Federal Trade Commission safeguards rules. Just about all of these are required under those rules. You have to have a written security plan. It has to be somebody in charge of that plan. You need to have staff training, and you have to keep on revising the plan. So AI, when the first requirements for the written security plan were there was no AI. But now, if you have a good written security plan, you have to include AI procedures and AI oversight.
Isn't one of the problems, Walter, that especially as to the AI component, but even more generally for a lot of the technology, some of the stuff, even the cybersecurity, it's so new and changing so fast. How is a firm to get a template of what's appropriate for them?
Well,
And more practically, what does a small firm or solo do?
I think what what a small firm has to do. There are I don't really know how many. There were three I'm really aware of. I've used two a lot of tax oriented AI platforms, BlueJ and CoCounsel, and Frank Agostino, who's a noted tax controversy attorney, he likes a program called Accord. I haven't looked at that yet. I want to. But when you decide to sign up with one of these, you have to ask them about their security page, and you have to learn. You have to do a little bit of learning about what the items are on that page. What does it mean that they don't take anything that you put in there and mix it in with the large language model, and they keep it isolated? What does it mean that if you do upload something, that it either is auto deleted or you have total control over the deletion, and once it's deleted by you, it's absolutely deleted? And there are a number of other factors like that that you need to have in place, and the The ones that are specifically tax oriented are a little more expensive, and they have contractual guarantees. They've got SOC 2 reports, which is a kind of report either by a CPA firm or certain other professionals, basically giving attestation on the cybersecurity in place, and that this way, and if you're using the cloud, and all, and when we did an experiment with CoCounsel, I asked them for their SOC 2 report. I got it. And our IT department went through it to make sure that it met all, that it had all the standards in there. So I think there are ways small firms can do things without completely understanding everything that's going on. But today, I think the ABA approach is much better than the AICPA approach to this. You have to be technologically competent, and you have to take reasonable steps to keep technologically competent, and be able to do due diligence and oversight. I don't think you have to have the technical knowledge to actually create AI. That's beyond it, but that's my belief here.
I agree with you, Walter, and I think that the ABA's approach was to say, hey, you have plenty of technical stuff you have to keep tabs on as an attorney. And if, for example, as an estate planner, it's really a challenge to keep up with just estate law changes. So you cannot be an IT expert. You don't have to be. You have to do what's reasonable, and you have to take reasonable steps based on what others would take. As to a firm procedure, I think what everyone's going to find more and more as you complete a cybersecurity insurance application, they're going to start asking for confirmation that you have a written firm policy, and you don't want to check that box that you do if you don't. So everybody's going to have to deal with this probably in fairly short order.
Well,
Bob,
I'll tell you, it's got to be dealt with, or this has had to have been dealt with since 1999.
not
Since
the AI
since
piece.
well,
The
not
AI,
the AI piece
right.
specifically, but the written security plan. And when you renew your PTIN every year with the IRS, there's basically a checkbox that you have. I think the question is, have you read publication 4557? I don't think they quite asked, do you have a written security plan in place? I don't remember, but 4557 is all about that, and that's basically the IRS's guidebook to the Federal Trade Commission's rule. So safeguard rules. So this stuff is really in place. And if something goes wrong and you don't have that written security plan and you get sued by a client, you're going to be dead in the water. That is an absolute legal requirement.
And now it
So,
has to be expanded for AI. So
and now it's got
they
to
were,
be expanded for AI. The rule itself says it has to be updated, regularly looked at and updated.
Tom, let's move on so we can
Well,
try to get
Marty,
through all these.
could I
Yeah,
please
sure.
ask Walter 2 questions? Walter, what if I take a document, a trust document, and drop it into AI and ask AI to review the document and to flowchart it? How do I know that my client's document isn't now sitting someplace where a bad actor can get to it?
That this is a matter of having a company that you've done due diligence with, that you develop trust, and you have a contractual guarantee that they won't do that. If you're using Blue Jay or you're using CoCounsel, there are contractual guarantees. I wasn't involved in the Blue Jay one, but in my firm I was very involved when we got CoCounsel, and I asked questions from beginning to end to get the SOC 2 report, to get other things, to see their security. And Blue Jay has a very good security page also. If you look at the results, they tell you what they do and what they don't do. And I think both of those systems have what you need. Um, Even if you get client consent to use AI, you still have to use a system that has all of these characteristics. that will pass due diligence. So it's really a two-step process. And certainly if you use unpaid ChatGPT or
Never, never.
any of those, you are definitely, anything you upload is getting mixed into the large language model. So you just can't do it.
So
And this is these are the 7216. I don't know if we're going to have time to discuss that, but these are the 7216 rules about consent.
So let me just give a quick example that's non-technology based that might help people understand the kinds of things you need to go through. If you have a firm that has a large amount of paper, you have offsite storage where you're keeping previous records. When you contracted with the company that holds your offsite storage, you were, as part of your ethical requirements, supposed to look to make sure that they were protecting that information, having an alarm, maybe having security, having fire suppression to make sure that the information doesn't get damaged. You do similar kinds of research for any company that's holding your electronic information, whether it's AI, cloud-based, just as you would have with old style offsite storage.
I think the key distinction is you're going to find that most subscription-based AI platforms are going to protect the data. You should not only assume that any free, publicly available AI is not confidential, but what in fact you should do is never use it. And let me give you an example because I thought of this actually just preparing for today. If you have any free AI, it's all going to the cloud for training, and it's not going to be it's not private. You just never can do it. Here's where another concern is. So let's say you have a subscription to Claude or Copilot or whatever, but one of your staff members is at home and just has a clever idea on a client matter Sunday afternoon and decides to ask AI a question. They know enough to know they can't put any client identifying information. But here's the thing. If they start saying it's an auto dealership worth $100 million, doesn't that already start to narrow down who and what it is?
Yes.
So it's not just not using the client name and address and business name. You really have to be very careful. I think the policy should be no one that works for this firm, our firm, can ever do anything for any client matter, even a hypothetical question, other than in the AI software that the firm has approved. If you get a clever idea, you wait until you can get to the firm subscription-based service. Don't do anything in a free AI ever.
I think that's a little strong, Marty. I'll give you an example of where I will use, if I'm involved in the state and I'm doing a 706 and the lawyer isn't that great, which has happened to me occasionally. I might put questions into AI about the New York surrogate court procedures related to something that I can make sure the attorney is doing without mentioning the client. I'll just ask what is the form that has to be filed, and I might even call the court clerk after that when I get that information. So I think you can use it for some general non-tax questions.
That's different than what I said. If you're putting in that it's an auto dealership worth $100 million.
Yeah, no, that's what you can't do. You can't put any specifics about the client.
Correct. And it's more than, it's not just a client name or identifying information. It could even be descriptive information. You got to be careful. That's why I think the better approach is if everyone in your firm has on their laptop, whatever Claude that the subscription that the firm is paying for, just use that. Then you don't have any issue.
Yeah, that's
I just could see people slipping up and putting in non-specific data, but it's still sufficiently detailed in the question that it could be a problem.
So one point that I want to make on this is both Walter and Marty are experienced practitioners that have the professional judgment where Walter can feel comfortable using the non-firm AI. But we're not just talking about the practitioners themselves here. We're talking about support staff, paraprofessionals, admin assistants. they will not have the same depth of knowledge and understanding and just restraint when it comes to providing information. So having a general procedure for the firm, similar to what Marty said, is more protective because it prevents those professionals from inadvertently putting information in without realizing what they're doing.
No, I absolutely agree with that. And that's, and this is part of the challenge for doing appropriate staff training. And also, it requires firms to make a certain amount of investment in AI platforms that aren't free. I mean, so I think that's absolutely required today. I think a firm who decides, we don't want to pay for AI and we're going to try to use the free stuff, I think is crazy.
Yeah, but see that goes back to your comments and concerns, which we agree with on billing, where the alert says that you pass cost savings on. It's not a cost savings. There's a lot of investment to do this, and the alert wants you to use this in a sophisticated, understanding way. That takes time and investment to do, but now they want you to pass on cost savings.
No,
It's kind of
that's-
inconsistent.
Yeah, I thought that was the worst part of the notice, actually.
Tom, let's go on and let's try to just get through this quickly. We got like 10 minutes left. My concern, and we've talked about it unless anyone wants to comment more, is that we lack in certain critical areas of the alert the reasonableness standard that is a common framework or standard in the ABA guidance. And I wish the IRS would reconsider that, because if you're doing competent work and you're doing reasonable steps, you shouldn't be taken to task for that. Let's go on to the next. On the right side, on the left side is the reasonableness approach from the ABA. You have to consider the sensitivity of the information, likelihood of disclosure. So for example, where Walter said he was asking general questions about probate in the surrogate's court, there's no sensitivity to that information. In my example of saying that it's $100 million auto dealership, you're starting to get kind of sensitive even though you didn't use a client name. In other words, the ABA has logical, reasonable factors to consider. In contrast, the way I read the alert is it wants comprehensive training, robust confidentiality, thorough review. Those words, I understand what they're kind of getting at, but what is comprehensive training? Did Bob's staff get enough training that it's comprehensive, or is it not quite comprehensive? Is it robust confidentiality safeguards? What does it take to be a reasonable confidentiality safeguard that is acceptable to the ABA? How much incremental safeguards do you need to be robust? And Bob clearly made a statement that they're going to review footnotes and read the ruling. That sounds pretty detailed and reasonable to me. Is that thorough? What does it take to be thorough? So the use of these terms and the alert is what concerns me. I get where the IRS is going. I don't disagree with what they're trying to accomplish. I just worry about maybe it's the lawyer in me, the terminology used. Tom, let's move on. We want to get through this. You want to comment? I think already addressed this.
Yeah, I think we've largely covered this already, but the point is, what is sufficient understanding of the underlying of how AI works? And it goes back to what Mari just said about the reasonable language that's been used in previous ethics opinions by the ABA versus the language we're seeing in the alert here.
I agree with Walter's characterizations. The IRS wants people to understand what the limitations are, to understand that hallucinations can occur, that it can have a bias to do something. If you ask AI to confirm that the client gets a deduction for something, it's like a teenager. It's going to want to make, well, maybe it's not a teenager. Maybe it's like a little kid. AI is going to want to make you happy and try to find something. But that's a bias. So you have to be careful. That we need to understand to use it effectively as practitioners. The technology behind it, and it's going to be it's changing so rapidly. Even if you understood it today, you're not tomorrow. But how much do you have to do? Let's go on, Tom. But keep going.
We've already talked about that.
All right, we've done this too. Let's go on. I think we're almost done.
Yeah.
What happens, Bob or Walter, if a client says, I don't feel comfortable paying for a detailed human review of everything? Like the example I gave with an LLC. I'll pay you for an hour for you to use AI to scan all these documents to find out what percentage gifts were made of an LLC, but I'm not going to pay you to have a human being go through, 1,000 pages of documents. How do you guys feel about that?
I'm out. I'm just out, Marty. I mean, you just can't, the clients have to let you exercise your good judgment. Otherwise, you don't have to do the work. They can find somebody else who's willing to shortcut it.
Yeah, no, I mean, basically, one of the most basic AI CPA ethics requirement is you can't subordinate your judgment. You certainly can't subordinate your judgment to AI. And if a client really wanted that, I think there are times a CPA or a law firm has to tell them there are other firms you can go to. We have to be able to use our judgment, know, and be satisfied ourselves that the answer is reasonable.
I'm not sure I agree, but let's go on. Tom?
So
What do you think about the prompts? Tom explained earlier what could go into creating a prompt. Do you feel firms are going to move towards having standard prompts? I think what many firms are going to do is use AI software where the prompts are pre-loaded, if you will, and you're not going to even know what the prompts are. So then the question becomes, if you're using a software product where you click a button that says research and you put in your question, you don't even know what the prompt is telling it to do. How do you know what's going on?
an important point to consider there is how do you know what the prompt is missing, which might be nuanced for your specific situation that might have given you a better answer if you knew what was going on in the prompt.
I think that's going to be a growing issue. I think the time to learn how to create prompts, to improve and expand prompts to accomplish different tasks is itself going to be almost an art that some, but probably not most practitioners will develop. And a problem we're going to have is, and this worries me in the language in the alert from the IRS, you don't know what the prompt is, the instructions that a software package has embedded in its program, or when those are being updated and what they may require. So how can you know? And they're not going to release their prompts because that's really their proprietary value. Does that make sense, Walter, Bob? Any thoughts on that?
I think that's why you have to review the results. And
But you don't know what the question,
you know what,
the instructions are asking.
even I mean, you know the query you put in. How
No.
they solved it, you may not be 100% sure, but you have to be satisfied that when everything is done, that you agree with the result or edit it.
Let me give you a quick example, Walter, and you can give me your thoughts based upon this. Let's say you have an AI program that can summarize legal documents and you feed a trust into it. You get a generic result based upon the prompt that that program had. But how do you know exactly which particular provisions the summary is looking for? Are you going for specifically a GST analysis of that trust? Is it general dispositive provisions? So there are some nuances that if you're crafting the prompt yourself when it comes to summarizing that legal document, you can incorporate into it. But unless you've got one of the, and I don't know because I haven't used the Blue Jay like you were talking about, Walter, or co-counsel, do they have those kinds of nuances to their prompts where you can click and choose?
Co-counsel, both of them have the ability to upload documents. Co-counsel specifically has like a separate methodology of actually uploading contracts, trust documents, and getting interpretations off of that. And as a CPA, I'm really careful because I'm not a lawyer, and I'm not going to upload a trust and give client legal advice. So, but I think it's for somebody who's for somebody like you, Tom, and Marty, I think it absolutely can be done. And it might be worth just trying it out and see how it is
You can use,
with the
Walter,
right clients.
you can use any AI to analyze a document.
Right.
But the nuance that Tom is getting at, it's not just uploading a document and clicking a button for that document to get summarized. It's what is programmed into that document. And that's what Tom means by the prompt or the instructions. What is it looking at? So if a CPA wants to know, is this a grantor trust? I think it's a grantor trust, and has any particular AI program review it for grantor trust status, the details of what's in the instructions embedded in that program will help determine what the output is.
Yes.
I agree with what you and Bob have been saying, that people with lots of experience will kind of know in their gut whether the output makes sense or not. But a lot of people are not going to know that, and relying on a prompt when you don't know what the prompt has in it. It's almost like we have four different associates. We each give an associate a research project. But the way Bob explains it is much more understandable than the way the three of us explain it. Bob's associate may come back with a much better result than our three associates because of how he explained the project to the associate. We don't know what's being explained to the AI associate if we don't know what's in the prompts, and the softwares are not, to my knowledge, any of them allowing us to look behind the curtain and see what that is. I think we do have to wrap up. Why don't we just go in order? Bob, any comments, thoughts, and then Walter, then Tom.
I'm glad, Marty, I'm glad you put this together. Walter, you've brought a lot of wisdom to this. Thank you for that.
Well, both of us are descendants of Sidney Kess, so
all of us, three of
all of
us,
us.
not Tom, but yes,
Not Tom, the three of us. So we had some good basic training there.
the best basic training.
The best. Yeah.
Walter, any other comments or thoughts?
I think this is this is a vital area. I think it's growing. I think firms have to be paying attention to it. I'm not quite as concerned on the language of the Circular 230 and thing they did. I don't know how quickly it was done. I don't know how much thought was put into it. I don't know, just like I say, you don't know what's behind the AI. I don't know what was behind, who it was at the IRS who actually put this together, or the approval process or anything else. So I'm much more on the side of reasonableness than I think you may be, Marty.
Tom, any last comments?
I think that one of the things that we've emphasized today is just how nuanced and how myriad all of these points that you need to consider when using AI safely in tax practice can be. You have the AI reasonable standards, you have some of the language that's used in the IRS alert, and like Walter said, there are different interpretations for how wide of a breadth the IRS's language takes us. But the core point here is that when we're using AI, we need to be thoughtful. We need to set up procedures. We need to use it with the same level of professional judgment that we have other tools and materials that we have in our quivers. So this is just another tool, and you cannot abdicate your professional judgment because of this tool.
I want to thank Bob, Walter, and Tom for joining me in the program. I want to thank Peak and ILS for sponsoring. I think we're all going to be having a lot more conversations about AI, and I look forward to it. Be careful. I can't remember the quote from Hill Street Blues, but something like "Be careful out there." It's a really rapidly developing, highly technical area with lots of potholes. I think in good faith, that's what the IRS was getting at. You got to be careful and prudent. My 2 cents is I wish they would take Walter's comment and use the word reasonable instead of a lot of the words they used, and we'd all be good. But it's all going to keep evolving. We're all going to see much more guidance from all sources and much more robust developments in AI. So good luck to everyone. Be careful, and thank you everybody for joining.